Welcome to our show, Everyday People Solving Problems. Each week on our show, we feature a person who has encountered and resolved a problem. We've heard each of our guests explain the type of problem they had and how they resolved it using the problem-solving systems that were available to them. In the case of problems with government agencies, there are rules for administrative appeals. Each specific government agency has its own name for the process and its own law and rules that govern it. Appeal systems for the Social Security Administration, Unemployment, and the Welfare Department, now in Washington that's Department of Social and Health Services, or DSHS, are designed so that people can access them on their own and represent themselves. The DSHS system is called fair hearings, and they are held before an administrative law judge, or ALJ. Today, our program features a man, Carlos Oliver, from Bremerton, Washington, who challenged a decision of the Welfare Department because he thought it was wrong. At the time the problem came up, Carlos and his wife and 2 children had moved from Oregon and were living in Washington, and he was going to the community college and finishing up his certification program in order to be able to work at his trade in Washington. Carlos's wife, however, was unable to work at all because she had recently had surgery and was getting chemotherapy. So they were receiving temporary assistance to needy families, or TANF, another acronym, from the Washington Department of Social and Health Services. Carlos only had about 3 months left to finish up his course, and he'd received 2 notices from DSHS. One of them said they were going to terminate his TANF grant because his wife, he hadn't proved, that is, that his wife wasn't able to work at the time. And the other notice told him that DSHS would reduce his grant or sanction it by reducing it 40% because he wasn't cooperating with the Work First program. We'll meet Carlos Oliver in just a few minutes, but first we'll show you what he did when he first got those notices.
Hi, may I help you?
Yeah, I hope so. I have 2 letters here that I don't agree with, so I'm asking for a fair hearing like I said I can do in here.
Okay, I have the forms right here that you need to ask for the hearing. You should probably fill out 2 of them because you have 2 letters, all right? And there's the forms.
Great. I also want to make sure I ask about continued assistance pending the hearing. That means I continue to receive my benefits pending the hearing, am I right?
Well, yeah, but you do know you'll probably have to pay all that back, right?
But it also says that if that does happen, I only have to pay back the last 60 days worth. Is that correct too?
Oh, yeah, actually, you're right. It is correct. Okay, well, go ahead and fill out the forms and be sure to include who's representing you or if you're representing yourself.
Is there any assistants representing me?
Actually, yeah, there is. Here it is. Here's a pamphlet that explains about fair hearings. It lists a couple of different places that you can call, one of which is Northwest Justice Clearline. It's a free legal advice line for low-income people. Most people do represent themselves in the hearings, and quite often people are able to resolve their issues prior to the hearing taking place. Also, if you do have any questions about your hearing or any concerns about your benefits, you can go ahead and give the Fair Hearing Coordinator a call. His name is Clay Parsons, and here's his contact information.
Great. Thank you very much.
You're welcome.
DSHS must send written notice of a proposed adverse action. The notice must contain the facts and rules relied upon in the action. Usually the notice must be in advance, that is, 10 days prior to the action. You can appeal an adverse action. That is called asking for a fair hearing. If you appeal within 10 days of the notice, you may have the right to continuing benefits.
Welcome to our show, Mr. Oliver.
Please call me Carlos.
Hey, I'll do that, and you call me Nancy, okay? All right. Thank you for coming today and sharing your story with us. We've never had anyone here who had this kind of a problem. And I had no idea that a person could actually challenge a decision of the welfare department. But a hearing, that sounds like a trial or something. You're not a lawyer, right?
No, I'm not.
No? And you don't have any legal training?
I do not.
Well, how did you know what to do, and what did you do next?
I took the advice that's on the pamphlet that the welfare office receptionist provided to me. The pamphlet had information about fair hearings and listed several website addresses. I got a lot more information from these following 3 websites. Also, Nancy, these resources told me about free legal advice at Clear. I called them and discussed my case.
To examine DSHS's file, to present evidence to testify and have witnesses testify, to cross-examine the DSHS's witnesses, to be represented at your own expense by an attorney or other person, to a decision made solely on the law and facts shown at the hearing. You will be notified of the date and time of the hearing at least 20 days before. If you need help and live in King County, simply dial 211 to access legal aid services.
The advocate helped me to figure out what to do next. She explained that sometimes you can solve your problems before a fair hearing by meeting with a fair hearing coordinator, and that I might resolve the termination issue that way. I knew that I had sent the paperwork in, and I kept a copy of it. Also, Clear gave me ideas for how to prepare for the sanction issue. The information I got helped me to know what would happen and how to prepare for the hearing.
Well, so then, Carlos, what did you do next after getting all this information?
I scheduled a meeting with the fair hearing coordinator, Mr. Clay Parsons.
Oh, you must be Mr. Oliver.
Yes.
Good morning. I'm Clay Parsons, the Fair Hearing Coordinator.
Okay.
Nice to meet you. Please have a seat.
Thank you.
I've had a chance to review your case. It looks like there are 2 issues here and actually 2 separate hearing requests.
Yes. One of the issues is that DSHS is saying that I have not cooperated because I did not send in the doctor's statement about my wife. But I did put it in the mail. I know that for sure because I made a special trip to the post office that day just to get it in the mail. I know I should have probably sent it in a little sooner, but I just...
Well, the Work First office did get them, but they were late, and so the letters crossed in the mail.
Can you withdraw that termination letter then?
Yes, we can do that, and that will solve that matter. We can tell the ALJ that at the hearing. By then you should have our letter withdrawing the proposed termination.
Great.
That leaves the matter of the Work First sanction. Your caseworker has told me that she didn't hear from you about her letter setting up the job interview. She said you just didn't show up. We sent you a letter asking you to come in and explain what happened, but again, we didn't hear from you.
Well, actually, I did call on February 20th and left a message for my caseworker. We had to leave town on a family emergency. I left that in the message. I said we planned to be back in 5 days. Then the car broke down, and we had to wait till the 1st of the month to get the part. So it was more like 12 days and not 5. By the time I got home, I saw the letter about the good cause meeting, but it was already too late. I called my caseworker. She told me that the sanction letter was already in the mail.
Mr. Oliver, here's the thing. Our caseworker said that you didn't call her or leave her a message. She said she wouldn't have taken the action to sanction you if she had gotten your message.
I know that I called, and I know that it was Ellison's message box.
Well, I'm not going to be able to settle this issue with you today. Our worker's willing to testify that you didn't call her, and we'll have to let the ALJ decide what to do, whether to uphold the sanction or not.
Okay, I will come back for the hearing next Wednesday, April 20th. What time should I be here, and where should I go?
You should be here about 15 minutes early, so try to arrive about 10:45, and you can check in with the receptionist downstairs. These are some copies of the documents that we intend to show the ALJ at the hearing. I'm going to give these to you today, and if you have any documents that you would like the ALJ to consider, I would appreciate it if you would give me a copy or fax me a copy before Wednesday.
Okay, I'll do that.
Okay.
Thanks.
You're welcome. Nice to meet you.
Likewise.
The decision maker is an administrative law judge, ALJ. The DSHS's representative is called the Fair Hearing Coordinator, also known as FHC. You are called the appellant.
Well, at least you got part of the problem resolved, or one of the issues at least. They agreed not to terminate your grant entirely and said they would send you a letter confirming that. Whew, that's one thing. But, you know, it sounds like they didn't even want to talk to you about that other issue.
You know, that's right. The Fair Hearing Coordinator just didn't want to even consider my side of it.
So then you had to get ready for the sanction hearing. What did you do?
Well, I knew that my caseworker would be testifying that I did not call her. I remember that my neighbor Mary Kincaid was over the night that I left a message. The clear advocate told me that I could have witnesses testify on my behalf. I asked Mary if she remembered the call and if she would testify to it. She said she would.
Write down your arguments ahead of time. Decide who your witnesses will be. Decide what other evidence, besides testimony such as documents, you will be presenting to the ALJ. Get copies of the documents that DSHS will use.
Well, it sounds like you were really prepared then, witness and all. But weren't you nervous anyway? What happened?
Yes, I was nervous.
Good morning. I am Administrative Law Judge Leonard Cruzy. Before we go on the record with this hearing, please introduce yourself and say why you are here.
I'm Clay Parsons, the Fair Hearings Coordinator.
I am Allison Whitney. I'm Mr. Oliver's Work First caseworker.
Carlos Oliver, I asked for the hearing.
I'm Mary Kincaid, and I'm here to testify for Mr. Oliver.
Thank you all. I have some documents here from DSHS and also from the appellant. Thank you for providing those ahead of time. Mr. Oliver, did the department provide a copy of these documents to you?
Yes, they did.
And these are the appellant's documents. Did the appellant provide a copy of these to you?
Yes, he did.
I am turning on the tape recorder now to begin this hearing. This is an administrative hearing being conducted in the matter of Carlos Oliver. My name is Leonard Cruzy. I am the Administrative Law Judge presiding in this matter. I am employed by the Office of Administrative Hearings. I am not employed by the Department of Social and Health Services. Mr. Oliver, you have the right in this hearing to be represented by any person you choose, an attorney, a paralegal, or a friend or family member. Such representation is at your own expense. You may qualify for a free lawyer through a legal services office in your area. If you want to represent yourself in this hearing, we will begin now. What is your choice?
I will represent myself. I'm ready to begin.
Let the record reflect that Mr. Oliver has waived his right to be represented by an attorney or other representative in this hearing. Mr. Oliver, the tape recording of this hearing, along with any documents that are admitted into the record in the course of this proceeding, create a record of your hearing and are the sole source of information that I may consult in making my findings and decision in your case. It is therefore very important that you tell me any information you want to have considered and show me any documents which you think should be considered for me to make a decision in your case. Do you understand what I've just explained to you?
Yes, I do.
The testimony given in this hearing is required to be given under oath. Would you please raise your right hand to be sworn in to testify? Do you, Carlos Oliver, Mary Kincaid, Clay Parsons, Allison Whitney, solemnly swear that the testimony that you are about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Thank you. Let the record reflect that the witnesses have answered in the affirmative. The testimony in this hearing is subject to cross-examination, which means that after one party has testified, the opposing party will have the opportunity to ask that party questions regarding their testimony. You may hear testimony in this hearing that you disagree with. You will be given the opportunity to respond to that testimony when you are given your turn to present your side of this matter. We will start the hearing by having DSHS present their side of the case first, and then Mr. Oliver will present his side of the case. Do you understand what I've just explained to you?
Yes.
The ALJ tells about the hearing and your rights. DSHS will present their side of the case first. You can cross-examine the DSHS witnesses. Next, you present your case, testimony, documents, and witnesses testify. DSHS can cross-examine you and your witnesses. To be evidence, the ALJ must admit your documents. Each side may give a closing statement to the ALJ. It can be in writing or oral.
Mr. Oliver, your request indicates that the issue to be determined is that you do not agree DSHS should sanction you because you believe you are cooperating with Work First. Also, there is a second issue regarding termination of TANF due to a Work First exemption issue. The parties agreed to have both issues heard today. It's my understanding that the Work First exemption issue is resolved. Is that correct?
Yes.
Mr. Parsons, has the department rescinded the termination notice?
Yes, Your Honor. The letter was mailed to Mr. Oliver yesterday.
Let the record show that the parties have reached an agreement as to that issue. Then this hearing today is about the Work First sanction issue only. Is that correct?
Yes, that is the issue.
Mr. Parsons, is the proposed 40% grant reduction the issue you are here to address?
Yes, it is.
I'm going to explain how the hearing will proceed. We will go over the exhibits individually first. As I go through the documents, please feel free to ask any questions that you have about any of them. Also, I will ask you if you have an objection. Examples of an objection are that a document is irrelevant to the issue in your hearing or it's unduly repetitious. In administrative hearings, our rules are not as strict as courts, but the rules are our guide to the weight I will give to your evidence. After we've reviewed the documents, the hearing will proceed this way. I'm going to ask the department's representative to present their case. Then after they have testified, the appellant will be given a chance to ask them questions. And then I'm going to turn to you and ask you to present your side of the matter and testimony of your witness. I will probably have questions of my own for the witnesses. At the end of the hearing, I will give both of you an opportunity to present a closing statement, summarizing your positions, or telling me anything else you've not had a chance to say earlier. I will not be making a decision on your case today. Are there any questions? Are you all ready to begin?
Yes.
I will describe each exhibit, first one side's exhibits, and then the other. Then I will ask if there are objections and decide to admit it or not. I will admit, normally, most items that are offered. Okay, the first document is the department's notice of termination. It's 2 pages. It's dated March 2nd, 2006, and I've marked it as Department's Exhibit Number 1. Are there any objections? Then it is admitted. The next document, marked Appellant's Exhibit Number 3, appears to be a phone company document. It's 3 pages, and in the middle of the second page there is a highlighted line. Any objection?
I do object, Your Honor. I don't believe this document is relevant.
What about that, Mr. Oliver? How is this document relevant?
This is my phone record for the month of February, and the highlighted line shows that I placed a call.
I will admit it then. Appellant's Exhibit Number 3 is admitted. Now we are finished with the exhibits and ready to proceed with the case. Mr. Parsons, you may present your opening statement if you have one, and your case.
Thank you, Your Honor. Mr. Oliver has not cooperated with Work First. We will show the facts about this case and why the rules require a sanction. I'd like to start by questioning our witness, Allison Whitney.
Yes, go ahead. Ms. Whitney is under oath.
Allison, please state your name and tell us what your job is.
My name is Allison Whitney, and I work for DSHS. I'm Mr. Oliver's Work First case manager.
How long have you worked at DSHS in this job?
For DSHS, I've worked there 18 years, and I've been a case manager for Work First for 8 years.
Mr. Oliver, do you have any cross-examination for this witness?
I do not, thank you. Ms. Kincaid, please state your name.
I'm Mary Kincaid.
Do you know me, and if so, how?
Yes, I know you. I'm your next door neighbor, and our kids play together.
Do you remember being at my house on February 20th?
Yes.
Mr. Parsons, do you have any cross-examination for Ms. Kincaid?
Yes, thank you, Your Honor. Ms. Kincaid, did you take any notes of this phone call?
No, I didn't, but I remember the call.
Thank you. That's all I have.
All right. Now I'll ask the parties to present their closing statements. First, DSHS. Mr. Parsons.
Your Honor, the purpose of the TANF program is to help families become self-sufficient. Our job is to make sure our clients get jobs as soon as possible. It doesn't have to be the best job. It just has to pay minimum wage and be in compliance with the wage and safety standards. The real reason Mr. Oliver has not cooperated with Work First is because he wants to finish his course at the community college so that he can get his license and work at his usual occupation. He is, however, able to work now, and under the rules, we cannot pay aid to a family where the parent chooses to go to school instead of working. The issue here is whether the appellant has cooperated with the Work First requirements, and clearly he has not. He did not respond to either the job interview notice or our letter giving him an opportunity to show cause for his failure to do so. The department has followed its rules regarding sanctions, and the sanction on appellant's grant has been properly implemented. In this case, the department took the proper action pursuant to the TANF rules.
Thank you, Mr. Parsons. Now it's your turn, Mr. Oliver. Do you have a closing statement?
Yes, I do. I have cooperated with the Work First program. It's true that I'm taking a class at the community college which will allow me to work my trade here in Washington. However, I did cooperate. When I got the letter about the job interview, I did try to call my caseworker. It was not possible for me to go to the interview because I had to go out of town on a family emergency. My friend, Mary Kincaid, was there when I left that message for my caseworker, and she testified to that today. I also have my telephone record which shows the call was made. I did believe we would be back in 5 days as my message said, but then the car broke down and we could not buy the part to fix it until after the TANF benefit was deposited on the 5th. But I did respond to the letter for the job interview, and I did have a good reason not to go to it. I didn't come to the meeting on February 28th because I did not know about the meeting until after February 28th. I did not refuse to go to the job interview, nor did I refuse to come to the meeting. I am trying very hard to get all the things done I need to do. I'll be done with the course in 9 weeks. I would, though, accept other work if it's offered. Because I am cooperating, I respectfully request that you find no sanctions should take place.
Thank you, Mr. Oliver. I will be issuing a written decision in your case in the next 2 to 3 weeks. My written decision will contain findings of fact and conclusions of law and will be final unless either party asks that I reconsider the decision. A copy of the rules about reconsideration and timeliness will be included with the decision. If the appellant does not agree with my final decision, whether or not he's asked for reconsideration, he can appeal it to either the Thurston County Superior Court or the Superior Court of this county where the appellant lives. If my decision is not properly appealed within the lawful 30-day time limit, it becomes final. Are there any questions? If not, then we will adjourn. Let the record reflect that this hearing is closed at 11:50 a.m., and I'm now turning off the tape recorder. Thank you all.
Well, Carlos, this has been most informative. And by the way, how did your hearing come out?
It turned out well, Nancy. The ALJ's decision said no sanction should take place. I finished my certification course and got that good job. A few minutes later, my wife was well enough to return to work also.
Well, all right. Well, thank you for coming today again, and congratulations on winning
Thank
your
you.
case. All right.
Thanks.
Well, folks, that's our show for this week. We've learned about the fair hearing process and what resources are available for help. Stay tuned for next week when we'll have another exciting show about an everyday person solving a problem.